morning. It's working now. Okay. We're going to go ahead and get started. We waited a few minutes to give folks some time to get in. It looks like, sounds like there was a pretty bad accident. But we're going to go ahead and get started. I just want to take it. You can't hear me? Wow, okay. So good morning, everybody. Just to let you know, we're going to do a flip on the panels. We're going to start with our solar panel, and we're going to do the urban ag panel after that. So please make sure that you can continue to get coffee and breakfast. I think that's going to continue, right, for a little longer? Okay. So good morning, everybody, and welcome. I'm Nicole Cook. I'm the Environmental and Agricultural Faculty Legal Specialist at the University of Maryland Eastern Shore. For the Agricultural Law Education Initiative. It's my pleasure to introduce Dean Moses Cairo, Dean of the University of Maryland Eastern Shore's School of Agricultural and Natural Sciences, who will officially open our conference this morning.
Thank you, Ms. Cook. Well, good morning. Well, a very warm welcome to the 5th Annual Agricultural and Environmental Law Conference. Let me begin by just bringing you warm greetings from my counterpart deans from University of Maryland College Park, Dean Craig Beiruti, and Dean Donald Tobin from the Francis King Carey Law School. It's really a delight to be here for the 5th time now with this conference and seeing the conference still continuing to garner a lot of interest. Now, the Agricultural Law Education Initiative has now been in operation for serving the citizens of Maryland for nearly 7 which I consider very productive years, having seen what's been happening over that intervening period. During this time, the initiative has developed many highly impactful educational programs. The team reaches stakeholders through a variety of avenues, face-to-face meetings, online, and in many ways, the team has been exploiting all possible ways to ensure that it engages the stakeholders in an effective way. So in addition to the diverse ways that the team has been engaging stakeholders, this annual event was created to bring the diverse stakeholders, yourselves, together to engage in a purposeful dialogue about supporting profitable and sustainable farming in a time of ever-increasing regulatory challenges. We are therefore honored to have with us today leaders in the industry in areas of farming, law, government, and academia. So with the variety of panels that we have today, we encourage you to ask probing questions of the panelists and to take advantage of the opportunities provided to engage with the people in the room, those seated next to you, because the group is pretty diverse. The ALEI team also continues to actively listen to stakeholders, to farmers, in order to identify those challenges that are current and to provide legal education and resources to help farmers gain a better understanding of the laws and their impact on their operations. As Marylanders, of course, protecting our region's fragile natural resources is a critical aspect. But we want to be able to do that while also ensuring that our state remains a national leader in terms of innovation and agricultural production. So this year's program, once again, is packed with a whole range of experts in various panels, and they will address a number of current issues that are of interest and at the intersection of agriculture and the environment. In fact, typically we've had keynote speakers. This time we will have panels really leading the discussion to be able to really bring that broad perspective. As Ms. Cook said, the program will be changed a little, but all the panels are extremely interesting. So for the last 6 years, the ALEI initiative and the specialists that lead the initiative from the University of Maryland Eastern Shore, from University of Maryland College Park, and Carey Law School have supported Maryland's farmers by listening to farmers who have told them about their legal challenges. And they have then gone on and developed legal education programs and resources to help those farmers gain a better understanding of the laws and the impact on their operations. Like farmers across the state of Maryland, those farmers from the Eastern Shore are grappling with keeping up with an evolving environmental, food safety, and other regulatory requirements. And I think having a dedicated legal specialist out of UMES really underscores our commitment as a university to serving the needs not only of the Eastern Shore, but of the entire state. But having a legal specialist on campus has also allowed us to partner, of course, with College Park and the law school to be more effective in terms of how we leverage resources across the three institutions to ensure that we address the variety of issues, risk management issues, especially in areas such as food safety, farm marketing, conservation, easement leasing, and business planning for urban, new, and beginning farmers. And the effect of this collaboration, I think, is evident with where we are today. So before I close, I would just like to check if there are any students in the room. Are there any students? Could you? Great. Well, we hope there will be more as the day goes by, but I think it's a special opportunity for students also to engage with those practicing in various different ways in agriculture and law. So let me take this opportunity to really extend my sincere thanks to the ALEI team, who I think do a wonderful job and work in a very effective way to continue blazing a new trail in this area and to ensure that they are effective in providing the educational programs to the citizens. And this conference is a good example of the team working very effectively. So I hope that today's program will be beneficial and will enhance your understanding of the agricultural and environmental legal issues that farmers are facing every day. So with that said, it is my distinct honor and pleasure to declare this conference open. And I hope that you will enjoy the sessions that have been programmed for the day. Thank you very much.
Good morning, everyone. Thank you for joining us here today. My name is Margaret Todd. I am the Legal Fellow with ALEI at the University of Maryland Carey King School of Law. I'm also a recent graduate of the University of Maryland Law School as well. It's my pleasure today to announce that our first panel is going to be Going Solar, the Roles of Local and State Government, post Board of County Commissioners of Washington County v. Perennial Solar, LLC. Our panelists this morning are Sandra McElmore. She is an Assistant Attorney General with the Maryland Energy Administration and works with the Department of Natural Resources Power Plant Research Program. We also have Leslie Knapp, who is the current Legal and Policy Counsel with the Maryland Association of Counties. And we also have Ryan Showalter, who is a partner with the firm McAllister, Datar, Showalter, and Walker, LLC in Annapolis. And he works with a variety of issues, including land use and working with developers in solar utilities. Thank you.
Good morning. Over the last 6 or 7 years, I've had the great opportunity to have a front row seat at the siting of the utility scale solar projects in the state. This is because of my participation in the Certificate of Public Convenience and Necessity process, a fancy name for the state licensing process here in the state. As Megan just indicated, I am an Assistant Attorney General with the Maryland AG's office, and I represent two state agencies, the Maryland Energy Administration and the Power Plant Research Program, which is part of the Department of Natural Resources. However, my remarks today are completely my own opinions and experiences, are not those of either the Maryland AG's office, MEA, or PPRP. Now, as I mentioned, over the last 6 or 7 years, I've been able to observe the siting of utility-scale solar projects in the state. Now, utility-scale solar is the larger land-based projects. They're over 2 megawatts. Roughly, based on a conservative average of a project which have been filed, CPCNs have been filed, a 2 megawatt project would require about 16 acres of land, give or take. PPRP, which I represent in many of these cases, is responsible for providing the Public Service Commission an independent analysis of a proposed project, both the socioeconomic, natural resources, and environmental impacts of the project, and coordinating with the reviewing state agencies to recommend to the Public Service Commission a recommendation of whether to approve or deny a project or approve it with certain conditions. Those conditions are to assure compliance with state regulations, statutes, and policies, as well as local and federal requirements. Now, the reviewing state agencies are those agencies whose mission is directly relevant to the siting of solar generation in the state. These include the Departments of Natural Resources, the Department of Environment, MEA, Department of Agriculture, Department of Commerce, Transportation, and Planning. In the past, CPCNs for generation plants or for more traditional power plants, those that have air emissions and other significant environmental impacts. And that is, however, with solar, there are none of these impacts, right? It's a clean, renewable energy. And that is precisely one of the reasons that Maryland has embraced the deployment of solar in the state. Now let's see if I can be able to use this. I might have to get help from Les here. How do you? It's not working, is it? Uh-oh. Well, as Maryland has important new climate change goals, we might have to just bag the. Well, I'll just go. Maryland has important new climate change goals to reduce greenhouse gas emissions, as we all know, and one of the ways to achieve this is a renewable portfolio standard in the state. Currently, the General Assembly has set a renewable portfolio, there we go, has set a renewable portfolio standard for Maryland to use 50% of the energy use in 2030 to come from renewables, and of that 50%, 14.5% should come from solar energy. So how do we achieve this RPS and solar carve-out? How do we best site good utility scale solar projects in the state? That is what the CPCN process is about. Now, full disclosure about this, I did not go to law school because of my math skills. I did have help with this, but it is just a rough estimate of what this goal may require. It is not necessary. It's just for illustrative purposes only. But based on the PSC's 10-year plan, the state's energy needs in 2030 will be approximately 54.5 million megawatt hours of energy. And to meet the solar carve-out, this will require that a little over 7.9 million be from solar energy. Currently, counting rooftop and land-based solar, we have about 1.147 million megawatt hours in the state. So approximately 6.76 million will be needed from solar. Now, converting the energy to power, megawatts, that would mean about 4,721 megawatts would be required from solar. Now, if we assume 60% of this will come from land-based solar, currently about 50% comes from rooftops. Most people that want rooftops have already put them in, so we can't really assume more than about 40% likely. So if we assume that, then, and we assume 8 acres per megawatt, that would be about 22,600 acres are still required for land-based solar. So I think it's safe to say we will likely need to continue siting utility-scale solar in the state. I'm not real good with these power plants, these PowerPoints. So what does utility-scale solar projects look like currently? What have we done so far? Now, the first state-permitted utility-scale solar facility was granted a CPCN in 2011, and it was at Hagerstown Correctional Facility, and it was about 20 megawatts. Now, as of November 15th of this year, we have approximately 34 final orders for CPCN. So that's about how many we have so far. Now, this doesn't necessarily mean the full amount. I need a helper, obviously, for these PowerPoints. And that doesn't mean, now this shows kind of where all these solar projects have been sited. That doesn't necessarily mean that the full amount will be operational or they will even receive their CPCN. They will be fully operational. But how can you assure that the project will be smooth, the CPCN process will be smooth, and they will be active? You do this by siting the solar correctly. Of course, the better sited the project, the more smoothly the CPCN process. And in order to assist the developers, local planners, and others, PPRP has developed a siting tool. It's called Smart DG, and you can go to it yourselves on the Power Plant Research Program's website. And it shows the infrastructure of the state between 3 and 4 miles of electricity lines, and then it also shows the availability of resources, where wind is, where land is, and also some of the constraints. For example, here's the prime, it shows the prime farmland. If you look here, all of the yellow is prime farmland. It also shows where the mouth parcels are. And all these mouth parcels are where the state's preservation easements would not allow utility scale solar to be sited. The next slide shows the zoning prohibition. So where all that shows where the local zoning would not allow them to be sited. Different projects, utility scale solar projects are different. They're not all the same. So, for example, for comparative purposes, if you look at Cherrywood Solar, it's a 202 megawatt project. It's the largest one thus far that's been sited, and it's in Caroline County. And then another recent one is Union Bridge, and it is only 8.2 megawatts, and it takes up 48 acres. So you can see that there's a big difference in some of the different projects that have been sited thus far. So what is the CPCN process? It is an administrative, procedural type legal process that there's an official record with sworn testimony and discovery. It includes an evidentiary hearing and public hearings. And the process takes a bit of time, particularly if significant concerns arise. Typically, it takes about 1 year. One important point to remember is that once an order is issued, the Commission will still maintain jurisdiction to assure that the applicant is in compliance with the CPCN and its conditions. As I indicated a minute ago, the PPRP files recommended conditions in each of these cases. Some of these require compliance filings, which I will talk about briefly later. Finally, the PSC, when it considers CPCN, it balances the benefits against the impacts. It does this under 7207 of the Public Utilities article. The first two bullets here are what's always been required of any CPCN, both for transmission and generation, which is a recommendation of the governing body should be considered, as well as the impact on the reliability and stability of the system and the impacts on natural resources, environment, and socioeconomics. On the last bullet, Les is going to discuss currently, and it was only recently passed, and it specifically addresses only generation projects. Thanks.
So good morning, everyone. Les Knapp with the Maryland Association of Counties, or MACO, and MACO is a nonprofit, nonpartisan organization that represents all 23 counties and Baltimore City on matters of legislation and advocacy before the Maryland General Assembly and occasionally at the federal level. I've been involved with energy siting for renewable facilities, particularly solar and utility-scale solar facilities, for about the last 4 years. And this has been a major issue of concern for the counties and actually the incorporated municipalities in the state as well. I think it's important as I go through this to highlight our position on solar energy siting. And basically, MACO does support solar energy development with local zoning and siting requirements as part of the project approval process. We do recognize that in order to meet the state's renewable energy goals, which Sandra talked about, there's going to have to be a mix of different types of solar projects. That includes rooftops on residences and homes, commercial on built businesses, community scale, which is generally considered 2 megawatts or less. That's kind of 10 acres or less, roughly, and utility scale solar projects, which are the much bigger ones that can take up dozens or hundreds of acres. We believe, though, at MACO that the solar project should be prioritized in the following manner. With a focus initially on rooftop and commercial solar. You're generating the energy on site, it's being used on site. That minimizes a lot of the grid and transmission issues you're going to have with some of the other types of projects. Second, as you do go out to some bigger scale projects, community and utility scale projects, put them on areas that don't have a lot of other uses. Brownfields, gray fields, and I'm talking things about parking lots, rooftops of warehouses, industrial areas, and also appropriate areas owned by the state or local governments. Things such as landfills and wastewater treatment plants often have a lot of acreage available to put solar on. Finally, as you do have to go out into open space, whether that's farmland or other types of open space, it should be in areas that are zoned for solar by the local governments with appropriate protections for things such as prime farmland, forest lands, critical areas and wetlands, other environmentally sensitive areas, and areas that may have some cultural or historical importance. So, the backdrop of that position has been informed by the recent Maryland Court of Appeals decision in Perennial. And that did say that the Public Service Commission has implied preemption over local zoning and land use requirements regarding the siting of solar or any other energy generation facility. Now that means that they have basically the final say of is there a yes or no in the approval. However, while MACO does view that case outcome as unfortunate, from our perspective, we do feel that that holding is still fairly narrow, and we've interpreted that does not eliminate the important role that local zoning does play in the CPCN process. The case does not alter or change the CPCN process that Sandra referenced, nor does it alter the PSC decision-making process, which the PSC has traditionally given great deference to local concerns. Also, the case does not change the scope of the CPCN process or the PSC. It is still limited to utility-scale solar or any other energy generation facility that has to go through the CPCN process. In addition, there are in state law due consideration requirements in the Public Utilities article that still apply. And so these requirements in the Public Utilities articles do highlight the role of local zoning, and it does require the PSC to give due consideration to, one, the position of the local government on any type of proposed energy generation project within their jurisdiction. That applies to counties and incorporated municipalities. It does mean the PSC has to give due consideration to the consistency of the proposed energy generation project with the local government's comprehensive plan and zoning. And finally, and this is also a very third important factor, they have to take into account any actions that the developer or others might have taken to address concerns raised by the local governments over the proposed project. That could include agreeing to things like setbacks or other issues. And these consistency and mitigating actions, the second and third bullets on this, were added as part of House Bill 1350 in 2017. And that was added because of a MACO legislative initiative where we wanted to ensure that local governments have an appropriate role and say in this process with their zoning. Finally, what are a couple of broad points on local zoning, and Ryan will dig down a little bit into that. But basically, local government should absolutely enact zoning for utility-scale solar projects. I've had some attorneys, some counties, and some other stakeholders question that in light of the perennial holding, but I absolutely believe that the perennial holding in no way mitigates the ability, or in some cases, what I think is the duty of a county to set up and zone for these projects. And different counties have taken different approaches to zoning. Some have created broad overlay zones. Some have special exception requirements. Some have total or individual project caps. It does vary. Any of these approaches, I think, can be successful as long as you basically create viable project sites. And by that I mean you take into account the locations where utility-scale solar could go with transmission lines, proximity to high voltage lines, or injection capacity. And you can absolutely limit or prohibit where you want it to go if you want to protect your prime farmlands, forest lands, or lands with other important uses. Zoning should also provide some certainty of the process for developers. Just like any developer, it should be clear what the rules are that developer needs to obey, what hoops they need to jump through at the local level as they move their project forward. But I do believe that any good faith zoning efforts that go through this thoughtful process will carry great weight with the PSC. Where preemption could be a factor is when you get into outright or de facto bans in your zoning or local regulations. I think that would invite preemption. And I would say to energy developers, it remains critical to reach out to any affected local governments as early as possible in the process. As early as you can, go and communicate and work through. I think you ignore local zoning at your peril.
Okay, and I'm sorry, I'm not real good at these PowerPoints, so I'm just going to ignore them from now on and just talk to you instead of trying to figure out where I am on that. As Les just indicated, the county plays a very important part in the CPCN process, and a developer should work very closely with the county from the beginning. There is a statutory requirement for the commission to consider the county's views, and also a statutory role for the county in the CPCN process. They can sit with the Public Service Commission at the public hearings in the county, and in some cases they have actually intervened in the CPCN process. And when they have intervened, they have played a very important part of that process. For example, in the application of Mills Branch Solar, Kent County intervened and provided testimony in opposition, as did another local group. And that was one of the very few times I've seen the Public Service Commission deny a CPCN application. Another important role of the county is with regard to compliance after the CPCN has been granted. This can be seen because the counties are local and they're the ones that go out, they get the calls, the complaints, they're the ones that assure compliance with conditions and permits. The commission does count on them to come and let them know if there's a concern with compliance. And a good example of where this has happened is in Great Bay Solar, which was a large utility-scale solar in Caroline County. And the county has worked very closely with both PPRP, MDE, and the Public Service Commission to assure compliance in that. and the applicant to assure compliance in that case. Now, with regard to the perennial solar case, so what is important about the perennial decision? It is true from a legal perspective, this case is important, as Les just indicated. It reasserted the PSC's and preemption authority to site generation projects and applied it to renewable projects. This case also highlighted the importance of renewable energy to the state now. However, like Les said, from a practical perspective in this case, it really didn't change the dynamics of a CPCN case or reduce the importance of the local jurisdiction's recommendation. So while this case underscores that the PSC has and continues to have the ability to use preemption to grant a CPCN over the objection of the local jurisdiction, this outcome has not occurred often. You can look to a couple of new cases that are ongoing currently, Biggs Ford and Lagore Bridge, and that kind of shows the parameters of where the commission may consider where it may need to preempt. That's just my personal opinion, but if you look at the Biggs Ford proposed order, it looks like Les said, that if there is a de facto ban, that might be a consideration for the commission. And at this time, once again, the important thing to remember is good siting, and I'm interested to hear how, I know that's better said, easier said than done, and I'm interested to see what Ryan says about how that can be done.
Thank you.
Thank you.
So those presentations provide you with a good context of the framework within which the solar industry has to work. There are a number of competing interests. On the one hand, there's a state energy policy that says we have to produce a lot more renewable energy than we have today. On another hand, you have local governments, you have the agricultural community interested in preserving farmland, you have neighbors and residents interested in maintaining landscapes and aesthetics. And then the solar industry has to figure out how to tie those two together, and of course, it has to have a profit. If there's not money to be made in the industry, there won't be participants, and we won't have the energy that is required. It's a very difficult balancing act, and sometimes three-legged stools are stable. In this case, it's a real challenge. And so there are a number of different considerations that come into play. The three general topics, I would say, are environmental and development constraints, state and local requirements or preferences, and then the landowner dynamics. And you have to balance and juggle all of those to pull together a project. One important consideration in siting are environmental features. I'm not going to spend any real time on those today. We saw very recently in Charles County that proposing to clear hundreds of acres of forest for siting solar is probably a tough way to go. But streams, stream setbacks, critical areas, steep slopes, endangered species, prime farmland, there are lots of environmental constraints that should guide solar developers' site selections. The biggest takeaway, I think, in trying to make utility-scale solar work in Maryland is the second bullet, and that's the development constraints. I've heard lots of concerns that the Eastern Shore will be paved with solar. Number one, we don't need that much acreage, but most importantly, the physical infrastructure constraints are what really drive utility-scale solar siting in Maryland and everywhere else. Electrons can't move through air. They need wires to go from the point of generation to the point of consumption. And so you have to use existing transmission to move those electrons from where they're made to where they're used. It's extraordinarily expensive to build transmission capacity or to upgrade it. So utility-scale solar really only can occur in an economically viable manner in close proximity to existing transmission infrastructure, and it has to be in a location where there is capacity. So it's not enough to have the line or the pipe. The wire or the pipe's got to be big enough. It's also very expensive to pay for interconnection. The substations and the infrastructure needed to put that power onto the line dictate not only project size and location, but the economics. And a lot of times you'll find that there's a certain threshold that or capacity that the line has. If you step above that, triggers millions or tens of millions of dollars in infrastructure upgrades. So sometimes that serves as a cap and keeps a project size smaller so that you don't trigger the next level of upgrades. At other times, a certain amount of upgrades are required to connect at all. And that may cause project sizes to be bigger because you have to spread those interconnection costs across a greater number of megawatts generated to make the project work. I'll talk a little bit about zoning in a second. Private land use restrictions, conservation easements certainly are a constraint that you have to work around. Aesthetics and mitigation, I have some slides and I'll touch on. Forest conservation is an interesting dynamic for developers. State law provides an exemption from the Forest Conservation Act for electric generating facilities that are approved by CPCN. We've seen that that's not something that the Department of Natural Resources, I think, likes or supports. And so it comes down to discussions with local governments. And so one interesting dynamic for both the local government and the developer, I would say, to address early, is some local governments say, we've adopted the model ordinance or the language in the Forest Conservation Act, and we're going to implement it. Your project is exempt. Others have said, doesn't matter what our ordinance says, we're not going to exempt you from forest conservation. And under the due consideration requirements, those projects are complying with the Forest Conservation Act. I'll touch briefly on taxation. And then the last dynamic is landowner considerations. You have to have willing landowners. And so it's not easy to go into an agricultural community and find enough owners who are close to transmission and close to each other to tie together 200, 300, or 1,000 acres of land for a project. As with all real estate projects, location, location, location is the key. Careful site selection is imperative to making projects work. And site selection is important for a number of reasons. One is you can largely influence the schedule and complexity of your process. If you avoid extra permits, your process goes more smoothly. The CPCN process is referred to by some as a sort of a one-stop shop. It consolidates a lot of different permits. So wetland permitting, groundwater appropriation permitting, lots of different permits can come together. But the more that you need, the more complicated it is. So if you can site well and avoid impacts, the process is easier. I talked about interconnection costs. The better you site your project close to infrastructure, the lower your costs are, the easier the project is to finance. And then the phrase out of sight, out of mind is probably not any more true with any land use project than solar. I hear all the time in public hearings, I support solar, or I'm not opposed to solar, but I don't want to see it. And if you have a project that's well sited, it addresses environmental features, and it's screened so that the public can't see it. I've got an example where people really don't care. People are supportive of it and don't come out. If it's seen, it's a different issue. And there are lots of other commercial and industrial uses where if they're out of sight, they're not out of mind because they have externalities. They have traffic, they have noise, they have air emissions. Solar has none of those. So if it can't be seen, it's often much easier to get it approved. So local government coordination. Perennial Solar did confirm that state can preempt local government authority if there's a reason to, but I think that application is very narrow. The Court of Appeals said that the local government is a participant in the CPCN process and has an advisory role. But what we've seen in CPCN approval conditions recently, I think, significantly undercuts or changes that. And this is a paraphrase of language from a recent approval. One of the conditions imposed by the state's approval is that before construction commences, the applicant has to certify to the Public Service Commission and PPRP that the facility was designed in substantial conformity to local zoning requirements and that it has received site plan approval and all required local permits. So it's kind of tough to say I have a state approval that preempts local law, but the only way I can fulfill the conditions of my state approval is if it's designed in substantial conformity with the local law, I get the local site plan approval and all the local permits. As Les noted, engagement with the local government early and often is a key to successful projects. So county zoning, Les alluded to this, there's a wide range of zoning in the state right now. Some jurisdictions are silent and don't regulate zoning. One jurisdiction expressly recognized preemption and basically said we're not going to play a role from a use perspective. Others have adopted a size cap. Talbot County has a cap that says we're not going to have any more than X acres of utility scale solar in the county period. Queen Anne's County has a floating zone, and they've created a corridor, which is basically 2 miles on each side of the principal north-south transmission infrastructure, and you can only do utility-scale solar within that overlay. So there's a wide range of solar regulatory schemes. It's important to understand those as you're choosing a site. If you're a landowner interested in solar, it's important to understand what the landscape is where your property is located. Some jurisdictions, solar is permitted by right, subject to site plan reviews. In most cases, solar is permitted by special exception, so it requires a project-specific evaluation by the Board of Appeals. One thing we're seeing with a lot of solar projects now is that jurisdictions don't want to see the substation on the road. They want the substation for the project to be buried back in the project so it's less visible. Typically, the utility companies want to own their substation parcel in fee simple. And so to avoid creating roads, public roads or private roads that go back into the project to satisfy road frontage requirements, we're often dealing with variances so that you can bury the substation in the project and improves the aesthetics of the project. Site design, site plan review is done by the Planning Commission, but the Board of Appeals typically is very involved in looking at the landscaping, the buffering, the screening, and takes those considerations into play when they're dealing with special exceptions. So this is a project in Queen Anne's County that I think is a good example of excellent siting. This is the Jones Farm project. It's about 325 acres of solar panels. It has forest on 3.5 sides of it. And so I don't think we have a pointer here, but there's on the north side of the project, there are 2 labels that are called out on Blanco Road. There's a small segment of buffer, about 1,000 feet or 1,500 feet of buffer. At the south end, there was a gap in the forest, southeast side, but there's another area of buffer. So this project had about 3,000 linear feet of buffer, so otherwise surrounded entirely by forest with 0 public opposition and very straightforward permitting. It's just an example of the types of aesthetic considerations and mitigation that counties look for and that the PPRP considers. These are some slides from a project in Queen Anne's County called Bluegrass Solar. This is a view of the current site, and then there's 3 renderings that show buffer planting at installation, 2 years after planting, and 5 years after planting. And so we're seeing a wide range of requirements from counties for landscape screening. One real challenging dynamic for the industry right now is that local boards want to see big immediate screens. Can you give us 10-foot trees? Can you plant 8-foot trees? Planting landscaping of that size is extraordinarily expensive. It's also very challenging to get 6, 8, 10-foot trees to survive, a summer like we had this summer, and provide effective screening. And we recently saw Dorchester County recognize that seedlings can establish much more quickly than large landscape stock and much more efficiently and effectively. We have a project approval there where half of the screening is going to be planted with landscape stock to hopefully provide taller, more immediate screening, and the other half will be planted with seedlings, which the industry believes will ultimately provide a more effective screen more quickly than the landscape stock. Briefly, personal property taxes and pilots are an interesting dynamic. A number of local jurisdictions have adopted personal property taxes on electric generating facilities, electric generating property. In Maryland, 50% of that initial capital investment is exempt from the tax, and then there's a 30-year depreciation schedule. So it declines at 3% or 3.33% per year. That means the highest personal property tax burdens occur on the project in its first year, and the revenue the counties receive declines over time. A number of counties have adopted taxes that are high enough. They're intended to be a steering mechanism. So if it's a project that the county supports, there's a way to reduce that personal property tax. If it's one that's not supported, if the project can be economically viable, I guess it can go forward, but often they're almost punitive and prevent projects from being built. So we're seeing payment in lieu of taxes agreements. Counties and municipalities have authority under state law to enter into an agreement to adjust both real and personal property taxes. And so what we're seeing a lot of is flipping the payment schedule so that payments are low at the beginning to help the project finance work, and payments escalate over time so that the county receives increasing revenue from the projects as county expenditures increase. And then briefly, and I think I had a couple of questions about how these deals are put together. There's generally two structures. There's a purchase agreement where the developer buys land from the landowner, and then the other typical approach is leasing. Leases typically have a 30 to 40-year duration. If you are a landowner or represent a landowner dealing with solar leases for the first time, it's certainly something you want to do a lot of research about or talk to folks who have experience. There are a lot of considerations to protect landowners on topics like decommissioning, making sure that that project is removed when it's over, making sure you understand what rights are granted and not granted that are pretty unique. And with that, I'll turn it back over to Les.
So as we noted earlier, solar siting remains an incredibly hot topic throughout the state and in all levels of government. And it's not just the Perennial Decision or recent county and municipal zoning efforts for solar that's going to be the be-all or end-all of this. There's a number of other groups, as well as the Maryland General Assembly, that are continuing to work on this issue. So what are some of those groups talking about? I think one of the biggest ones out there right now is the Governor's Task Force on Renewable Energy Development and Siting. That was established earlier this year through executive order, and that is studying and making consensus-based recommendations on the siting of clean and renewable energy projects, which would include how to accelerate and streamline the siting of projects in desired areas, which they specifically call out as already developed land, brownfields, and parking lots, while also minimizing the impact of projects sited in less desired areas, such as prime farmland, ecologically sensitive areas, or other types of culturally important lands. And these recommendations must recognize and respect local government legal authority and private property rights. That's part of the executive order that created this. So this work group has been meeting for, I think they've had 5 meetings now, mainly by phone. They're actually going on a site visit tomorrow to see a couple of projects in Anne Arundel County, and I think going across the bridge to Queen Anne's County for one. And they're going to come up with recommendations preliminarily this December. That could include recommendations for legislation and certainly policy changes or regulatory changes at the state level. In addition, the Maryland House of Delegates Environment and Transportation Committee has established a work group specifically on solar development. They've had one full formal meeting to look at this issue. They will probably meet one more time before session, although that's not 100% clear. The interesting dynamic in this group is the chair of the committee is very much in favor of putting utility-scale solar out there on open space and farmlands as much as possible, and actually not focusing any type of resources on community scale or rooftop development. And his basic belief and premise is that's the cheapest way to get this. We need to get to our renewable energy goals, and that's by far the cheapest. I do think that there are a lot of other members on the committee, as well as other stakeholder groups across the spectrum, that don't share quite that level of belief in utility scale solar. So the committee, I think, is trying to work through and what is a reasonable approach. The Senate Finance Committee also had an energy briefing on September 16th, and utility-scale solar siting was briefly discussed, as well as expansion of net metering, which is a way that these, especially for a community-scale project, that one of the smaller ones, can put energy onto the grid and sell it rather than just use all of that energy on site. And I think that's definitely going to be part of further discussions on solar development. There are some grid issues there, and utilities have some concerns, so that's got to be worked through. Yet another player is the statewide Joint Land Use Survey Implementation Committee, that's a mouthful, that is looking at an alternative energy siting project. Now, the Implementation Committee basically takes a survey of all of the military facilities in the state and makes recommendations on land use, either at the state level. They could make recommendations on local zoning and turn those into mandates and propose legislation on that. One thing that they have now taken up is looking at alternative energy and citing that, because sometimes solar and wind projects can be disruptive of a facility's mission or potentially conflict with their long-term plans for expansion. So they're trying to take a look at this in concert, I think, with some of these other groups and not try to step on anyone else's toes, but to basically say, where do the military facilities have concerns about putting solar or wind, and where could they encourage those sites, including within the base itself. They want to look at where we could maybe put some alternative energy in to help with the state's goals. So that's still in its very early formative stages, but is something to pay attention to. Finally, directly for the 2020 session, I would expect at least at a minimum legislation similar to Senate Bill 744 of last year that established a commission on the development of a blueprint for solar energy in Maryland. I didn't really touch much on that because I think the governor's executive order encapsulated a lot of what that legislation did. So it would be, again, trying to figure out how to incentivize solar and map out where you want utility scale solar in areas that are desirable for it, and try to discourage or disincentivize development on areas where you don't want it to go. I think you will also see, as I said, the preliminary policy, regulatory, statutory recommendations from the Renewable Energy Task Force. And I think you could see legislation that not just on zoning, but will also touch on state or local revenue authority regarding solar energy projects. And I think Ryan mentioned that local fiscal authority can be a great incentive or disincentive on a project. If they like a project, they can certainly reduce the burdens of that project in terms of paying local taxes. But also, if a county doesn't like a project or municipality, they don't have to give any breaks and can put their full taxation authority into effect. That's how it works with all types of development now. And I think, at least from our perspective, we would guard that very jealously. Finally, beyond the 2020 session, to wrap up, you'll see the final recommendations of the Renewable Energy Task Force in 2020. You're going to have increasing pressures to meet the state's energy goals, so you're going to have some borderline projects it's going to get a lot harder to say yes or no to. Yes, they have to cut down some trees, or yes, maybe we're building a little bit on wetlands or on prime farmland. You'll have to look at the whole of the project to do that. But as we do address two, we get to around 50% renewable energy or more. There's going to be some major grid infrastructure and storage challenges that will have to be addressed. And that's something I don't think the state, I know like the Power Plant Research Program and the agencies are looking at, but I think the state and General Assembly as a whole haven't really dug into yet that we'll have to deal with. And so with that, I think we are done.
Is yours working? Okay, there you go, sorry. Thank you very much to the panelists. Are there questions for the panelists? Questions, Colby?
For the first speaker, when you guys did when PPRP looked at all the siting maps and looking where, I guess your smart grid that you have, from everything we're hearing from the commercial solar side is that within a half a mile radius off of a transmission line is the ideal place to put a solar site, commercial solar. Have you guys done an actual assessment of how many acres would actually be eligible in the state so we could quantify? I mean, there's 2.2 million acres of agriculturally zoned land, which we know the vast majority of that would not qualify because it's not adjacent to a transmission line. So do we actually know how much land is actually out there that would potentially be available so we could start to try to quantify on what does 22,000 acres really mean in agricultural land?
Not of which I'm aware. I do know that the Power Plant Research Program is also tasked with coming up with a renewable portfolio standard report that is due to the General Assembly at the end of the year. There's an interim already there, and it does go into the feasibility of the RPS, but I don't know if it's going to go to that detail or not.
That would help us to know what the impact really would be.
Okay, I will let them know.
Other questions? Other questions?
Do you want to just talk about Shugart and how that went on? Because I think that illustrates a lot of these trade-offs and balancing acts that you're trying to address.
Maryland Solar. To be quite honest, I'm not going to be able to talk too much about that because it's litigation that I was involved in, but perhaps maybe Ryan could talk about it some if he has.
Well, actually, I don't have personal knowledge about that project, so unfortunately I can't.
Yeah, I was personally involved, so I really can't talk about it. I apologize.
Any other questions? Joe?
Yes, Ryan.
Yes, sir.
From an area that's been bombarded by solar requests, we see a lot of those schematics of what the landscaping will look like. And the history is, if you go look at the actual projects that have been completed by the same companies, they don't look like that at all. And I guess maybe for Nancy, does the Public Service Commission go back? We don't have in the county enforcement rules once they go for public. Our private, our solar, our community solar projects, and our homeowners and our farmers screen them perfectly. And the county enforces those screening rules with bonding and issues. But the industry doesn't. What you see out there is not what is in those pictures, small or large. And you can drive by them and see that now.
Joe, I wouldn't disagree, and I think one of the challenges the industry has that I have as an advocate for projects is there has been relatively little utility scale solar actually constructed, especially on the Eastern Shore. And what has been constructed is constructed with what I would say substandard landscaping and buffers. That's based on the requirements that were imposed or not imposed in the infancy of this industry. And there are a number of projects that are very visible that were approved with very little thought given to screening, no planting agreements, no bonding agreements. And so when the minimal screening that was proposed wasn't implemented, the county didn't have enforcement authority. Those projects are also providing tremendous impetus both at the state level and the county level to change the dynamic. So I don't think any project that's built on the Eastern Shore proposed anything close to the screening that I share, which is why you don't see that. But that's what is the current standard and expectation, and now it's being backed up by significant bonds. So I think when projects that have been approved within the last 2+ years are actually constructed, you'll see something very different than what you've seen to date.
However, having said that, the Public Service Commission does have compliance authority, and in some instances, the county, it's been a learning process. We've learned a lot since the beginning. And so at the beginning, the conditions and the county's conditions were a little less significant as they are currently. Having said that, if they aren't in compliance with this, the counties can go to the Public Service Commission and let the Power Plant Research Program know, which they're probably going to kill me for saying that, but they can go there and get assistance to assure that they are in compliance. So that is another tool.
Okay, please help me in thanking our panelists today. I think our panelists will be around if there's any more questions. Oh, I'm sorry, Kyle. I'm going to let Kyle go because he's one of our few farmers who are in attendance today. He came during harvest, so he gets an extra question.
Yeah, I have real concerns, local concerns about the impacts of the large-scale projects. The one I'm familiar with was going to be on a couple thousand acres of prime irrigated farmland. So I have real issues. It seems like it's trying to be directed, but it's rippling through the community, and it's a big deal. And I think it's kind of short-sighted in the fact that, some of the crops we grow here are deficient. We're shipping them in from other areas already. And then we go ahead and we reduce our food and producing land. So I think it's just short-sighted on prime farmland. Thank you.
Thank you, Kyle. Okay, thank you, panelists, very much. I appreciate that.